Hi, this is Kevin Snyder of Snyder Law, and I'm an estate planning and elder law attorney in Irvine, California. And I'm coming to you today with a very important message and alert regarding Proposition 19. As we draw close to the final date in order to act before Prop 19 goes into effect, I am noticing a trend towards rushing out and trying to seek very fast, easy, convenient solutions. And that is filing the quitclaim deed. The deadline to act is going to be, for most people, tomorrow, February the 11th, and for some, February 12th. And that's because the recorder's offices in all counties are going to be closed on February 15th, which is President's Day, and Proposition 19 goes into effect February 16th. So there's little time to act. And people are going to be rushing out and trying to put solutions in place. And what do we know? Haste makes waste. And that is very true here. That is because a quitclaim deed, while it would be effective to utilize Prop 58 parent-child exclusion right now, there's a lot of other ripple effects and damages that you can be doing when you're trying to seek a short-term solution and not realizing the long-term effects. So a quitclaim deed could be the right solution for you and your family, but only after having a conversation with an estate planning attorney who is knowledgeable in property law. And after that conversation, if the advice is to do it, then by all means, follow the advice that you're receiving. My concern is that a number of people are just going to rush out and be reactive because they're concerned about this impending deadline and not realize some of the impacts. What are those impacts? Number one, you're deeding over property to somebody else, your child, either in part or in full. By putting your child on title, you're giving them ownership. Or if you're transferring ownership 100%, they have 100% ownership. This can be a problem, especially because your property is now not controlled by you, either in whole or in part, because it is now subjected to your child's liabilities. Yeah, sure, your child might not throw you out on the street. That's not your concern. But what happens if they go through a divorce? What happens if they get sued? What happens if they have some bad debt and they have creditors come after them? You can be out of a home. You could be out of your property. That's unfortunately what happens sometimes when you share ownership with another person. In addition, there is the capital gains problem that we have to look at. By deeding over your property in part or in whole to a child, you are forfeiting the step up in cost basis that they'll receive when they otherwise inherit it from you. That's significant because the step up in basis is a huge tax break for children later when they decide to sell the property. Capital gains is a tax on appreciation from the acquisition of the property all the way until it is sold. That's your gain. So if you sell your property now, you'll be taxed on the appreciation from when you purchased it to when you sell it. However, that will be forgiven when you pass it to your child on your death, because now the new measure of appreciation is going to be the date of death value of your property until the time your child sells it. So that really fast, quick, convenient, easy, inexpensive deed transfer. If your primary home, you could probably do it for around $30. If it's not, it's going to be somewhere in the marketplace of $125 to record it at the county's recorder's office, if you can still get in there to do that. If you do that, that's a very inexpensive short-term expense, but now you're talking at possibly tens or hundreds of thousands of dollars of tax that you have just shifted over to your child. As a quick example, if we're talking about $1 million worth of appreciation, which isn't a hard thing to fathom when we're talking about perhaps owning your property for a couple decades, that appreciation would be taxed at about 33% between the federal government and the California state government. 33% of $1 million is $330,000. So that real quick and easy $30 deed transfer of your home really cost your child $330,000 in that example. And you're not going to realize that immediately. Your child's not going to realize that immediately. That's going to be realized much later when there's nothing that you can do to fix that. Also, if you realize this mistake later, after the 16th, and you want to undo the transfer by having your child transfer it back to you and say, hey, look, we don't want to have this capital gains tax problem, that's fine. You can do that. But by the way, that's going to trigger a property tax reassessment for which there's no longer a parent-child exclusion. Because remember, it worked both ways. A child can give property to a parent with an exclusion under Prop 58. That's going to be gone now. And depending on if you live in the home or not, this might be a real issue when it comes to whether or not your property that you own is going to get reassessed now. So it's important that you really think hard before you rush out and try to record these things, particularly here in Orange County, when now you can record in person. Other counties, it's not even possible to get into the recorder's office without talking to an attorney, but you should be talking to an attorney before you do this. So I cannot urge strongly enough that you do this. If you're saying, well, no, now I'm going to be out of luck. Well, the news is that there's probably going to be some other solutions to look at. And you shouldn't take a step forward without having counsel. So I can't tell you what to do. All I can say is what not to do. Don't do this without talking to an attorney. It's super important. That's my public service announcement. My name is Kevin Snyder, Snyder Law. I'm an estate planning and elder law planning attorney, and we help families plan to protect what matters most to them. And hopefully this was of value to you. Check out some of our other videos on here about estate planning. But for those of you worried about Prop 19, I hope that you really heed the advice here. Okay, thank you very much. I'll talk to you soon.